Hi, this is Tanil Jankola, and this is my presentation on tort liability for EDL 850 School Law, Module 13. According to Black's Law Dictionary, a tort is a civil wrong for which a remedy may be obtained, usually in the form of damages, and according to Essex, a liability may result from deliberate acts committed by another or acts involving negligence. A tort liability, then, is a deliberate act committed by one person on another or an act of negligence that results in a civil wrong or injury in which a remedy must be obtained, usually in a court of law where evidence is evaluated to determine who the liable party is. The cases that I reviewed were Spears versus Jefferson Parish School Board, Brown versus Fallon versus Indiana Trail School, Brown versus Tasek, Johnson versus the School District of Maillard, and Hammond versus the Board of Education of Carroll County. In the first case, Spears versus Jefferson Parish School Board of 1994, the Louisiana Appellate Court held that a school was liable for damages when a physical education teacher played a trick on a kindergarten student, telling the student that one of his classmates hanged himself. The student, who believed his teacher and believed that his classmate was dead, experienced severe mental and emotional trauma. He was diagnosed with PTSD, separation anxiety, and social phobia disorder. The school was held liable for $100,000 in general damages, $2,160 for therapy, and $5,000 to each parent for loss of companionship with their child. Reactive measures in this case, I believe we need to investigate the incident fully, gain all the facts. 2, definitely immediately take care of the child and his mental well-being. And 3, we need to investigate the teacher and the qualifications of the teacher. There would possibly be a suspension, if not termination, of this teacher. Proactive measures to make sure we are hiring qualified teachers, that we are checking them completely, their background, their references, and that they are qualified to be in a classroom with young children. And second, to educate our staff on appropriate conduct. From professional ethics, suicide and death should never be used as a joke. In our day and age, we deal with that so much within our young people that it is nothing to joke about. We need to be using good judgment and to know that death is not something that is funny. In Fallon versus Indiana Trail School of 1986, a sixth grade student incurred a spinal injury while performing a front drop on a trampoline. The student's mother took the school to court on 4 different counts. 1, stating that the school was strictly liable for exposing their children to abnormally dangerous equipment. 2, for negligence on the school's part for allowing them to even be on the trampoline, for negligence on the school's part in their hiring of the PE teachers, and for willful and wanton misconduct of the school and the teachers. The Illinois Appellate Court held that the student was not entitled to damages for the spinal injury and said that the school and PE teachers were not strictly liable because a trampoline is not typically a dangerous device and that abnormal use of a trampoline is not a hazardous activity. Reactive measures would be to definitely investigate the entire situation, to investigate were the teachers supervising, were they where they needed to be, did they educate the students on proper use of a trampoline, those types of measures. Proactive measures, I believe, were to be to definitely have safety policies and procedures set up when equipment of this nature is used, to make sure that the students are trained on proper use of such equipment, and to maybe even offer a waiver or some form of permission slip to where if parents do not feel comfortable for their students to be on equipment such as trampolines, to give their consent or to give their refusal. Professional ethics would be to make sure that we are supervising our kids at all times, that we are making them follow the instructions that we gave, and if they are not being safe, to remove them from the activity and go back over safety procedures with them. Also, use good judgment. In the next case, Brown versus Tasek of 1990, the Louisiana Supreme Court held that a school board was liable or could be liable for injuries suffered when cans of duplicating fluid were taken from a dumpster outside of the school, ignited, and severely burned a student on his chest and face. The school board had a policy that did acknowledge its duty to properly dispose of cans. However, the court found that the school did breach its duty by not disposing of the cans correctly. The court awarded $451,000 to the plaintiff. Reactive measures would be to investigate what happened, and two, to make sure all other cans are removed from the dumpster or other dumpsters around the school if there are more than one. Proactive measures is to definitely educate and review the policies that are in place on proper disposal of such hazardous material or flammable materials, to make sure that our staff are following those procedures, and to maybe have within that, and to let your teachers know of just a general location, because each class was given one can of the duplicating fluid, that when it became empty, that there was a general location for them to take their cans and place them, so that either a administrator or custodial staff would be the only one disposing of them. Therefore, you're ensuring that they are being disposed of properly. Professional ethics, follow the policies that are in place. Know what the policies are. Do your job and do your duty to the best of your ability, knowing that that is a high traffic area, high violence, high crime, high theft. When you put something in a dumpster, such as an empty can, I have 3 boys, and knowing their imaginative minds, something's going to happen. So use good judgment. Follow the procedures that are in place. In Johnson versus the School District of Maillard of 1998, the Nebraska Supreme Court upheld damages awarded in the amount of $20,000 where a first grade student was injured playing London Bridges in music class. Now, the teacher had instructed the students on how to play the game, even modeled using 3 students to show how the game was played, and allowed the students to begin playing the game, telling them not to get loud, not to be screaming, not to be rowdy and rambunctious. This was the first time that the class had played London Bridges, and the teacher who allowed her class to go ahead and start playing was not supervising the game. She was writing on the blackboard, and the student was thrown into a bookshelf when the 2 students rocking him back and forth accidentally let go. The court determined that the teacher should have foreseen the injury, and that the injury was the proximate cause of the teacher's failure to supervise. Reactive measures, again, investigate completely the situation that took place. Investigate, was the teacher supervising? Was she paying attention? Had she instructed them on how the game was played? Was she making them follow the rules? Proactive measures, to have, again, policies and safety procedures in place, making sure that our teachers understand fully that we have to supervise our children at all time in every activity, especially an activity that is involving young children and they've never played it before. And it does get kind of exciting when you're doing London Bridges. We've all been there when we are rocking somebody back and forth. It is not always necessarily the easiest of rocking. So to make sure that we are supervising, make sure we are paying attention, to educate our staff on doing that, which also follows into professional ethics. Make sure you're paying attention. Know what's going on in your classroom at all times. Have those policies in place. Know what could happen and be prepared for it. In Hammond versus the Board of Education of Carroll County in 1994, Tawana Hammond, who was the first female football player in Carroll County, was severely injured in the team scrimmage. Her family took the school to court, citing that the school was negligent in not warning their daughter of the potential harm of playing football, and sought $1.25 million in compensatory damages. However, Tawana was not immune or not unaware of risk that took place with football, as the case said, that she had watched football since she was 6 years old. She also played in other sports at the school, so she knew that in order to participate in the sport, they had to sign a permission slip, which she and her father did. The court held that Tawana assumed the risk of the activity and would not accept the plaintiff's argument. Reactive measures, make sure that the medical condition of the athlete, of Tawana, was immediately handled and taken care of, and to investigate further into how she was injured and why she was injured. Proactive measures, definitely having that permission slip in place. Giving a set of potential risks to parents, educating them on what are the potential risks and of each sport, especially when it's a contact sport. Professional ethics, to make sure that our students playing sports are aware of how to do certain things, tackling those types of measures correctly. Are they doing what they need to do? Are they educated enough on the game that they're playing? And to make sure that we are paying attention and aware at all times of what is going on. Thank you for your time and have a great day.